Good morning, Keller Williams. This is Lorraine Bennick, and today we're going to talk about COVID-19, their forms, and the uses of those forms. So let's go ahead and get started. First, there are forms both for our residential and our commercial use. We're going to talk about we're going to talk about residential first. Some questions that we've been asked is, can a tenant stop paying rent? And the answer is no. Can a landlord evict that tenant? Again, the answer is no, except for criminal activity or physical harm. Per the Federal CARE Act, all filings for evictions and all late fees from March the 27th to July 24th are prohibited if the property participates in a federal voucher program like your Section 8 programs, or has a federally backed mortgage. And since most of our mortgage are federally backed, if it has a mortgage at all, I would say it's probably covered by that. But if it doesn't have a mortgage, can they then evict? The answer again in Texas is no, because per the Texas Supreme Court, all evictions are halted through April the 19th, and all writs are halted through the 26th. Writs would be where the documentation is given to the sheriff to go and evict the person from their home. So through the 26th as far as writs go. But local agencies such as your counties and your cities, they can impose their own rules and restrictions in addition to that. So the city of Houston or the city of Katy, Harris County, Fort Bend County, they also could add rules of their own, extending those dates to another date if they chose to. So can a tenant refuse showings? It's possible that he can if the tenant happens to be part of a high-risk group and you can't make reasonable accommodations. So if that is the case, I would consult a real estate attorney or advise your landlord to consult a real estate attorney. But even if they're not part of a high-risk group, we want to be concerned for the health and safety of not only the tenant, but whoever they might be showing the property to and the homeowner themselves. So all of the people should be screened before they enter the home, and everything should be wiped down. All precautions should be taken. The fewer people, the better. So we have a form called the Certification for Property Access, which asks a person who wants access to certify that neither they nor anyone they live with has experienced any flu-like symptoms in the previous 14 days, has currently been diagnosed or has a test pending. They're currently under quarantine because of COVID-19 concerns. They've had contact in the previous 14 days with someone who was diagnosed, or contact with someone in the last 14 days who had contact with someone who was diagnosed, or they've traveled in the last 14 days to an area designated as a widespread ongoing transmission center by the Center for Disease Control. If any of those things apply, they would need to let us know. This is the actual form right here. You would fill in the property address, the date they visited, who the seller is, who the listing agent is, all of the information about the people who want access to the property. And then those things that I explained to you, to the best of their knowledge, they're certifying that none of those things have happened. Now, it specifically states on the form that this certificate does not create a legal binding contract or enforceable obligation or modify any right or obligation in an existing contract. What they're basically saying is you can't decide that I'm going to sue because later on one of these people develops COVID-19, or you do as the seller or the tenant. If they wanted to sue on that basis, I would recommend that they consult with the real estate attorney. But this form isn't used for that. It's basically to give everyone a little bit of comfort in that at this time, the person who is entering that home probably has not been exposed, and they've wiped down, they've done all the things that we've asked them to do, so we're okay. It just gives a little bit of peace of mind. Okay. But what if the tenant can't pay rent? That's a totally different issue. The first thing I'm going to tell you is have a conversation with the landlord. Encourage your tenant to call their landlord and let them know what's going on so that they don't violate the lease in any way. If the landlord and the tenant have a conversation and they decide that they want to modify the lease payments, then we would use the form TXR 2227. And understand they have to have written proof of a job loss, a loss of income, or other monetary hardships. So in this case, the tenant is facing financial difficulty for some reason that has to do with COVID-19. So they agree to a temporary flexible period of paying rent, whether it's paying half the rent, paying a quarter of the rent, whatever it is. But this is the time period we have to put in. And then in order to qualify for this, the tenant has to show written documentation of loss of job, income, or other monetary hardship. And the determination of the sufficiency of that document is totally up to the landlord. It might be a letter from their company showing that they were laid off. It might be a letter from their ex saying that here's a letter from my company showing I was laid off, therefore I can't pay child support. Whatever it is, there has to be some kind of written documentation in order for the landlord to review it. And then the tenant agrees to pay at the place where rents are always paid according to the lease, future due dates as follows. So let's say he only paid half his rent for the month of April. So in June, he's going to pay, rather than $1,000 rent, he's going to pay $1,500 rent on June 1st in order to make up that half a month rent that he didn't pay. And you can see we have 4 lines here, so you could do that up to 4 months. In addition to the payments, tenants shall timely pay all other amounts under the lease and comply with all other provisions of the lease. All of the provisions of this lease stay in place even if you do this modification. The only thing that's changing is we are temporarily allowing the tenant time to catch up during a job loss, and we are modifying the payments for however many months that we're doing that. But it doesn't change any of the landlord's rights under the lease. It doesn't change any of the tenant's obligations other than this payment. The tenant continues to reside at the house, and the landlord, if he's begun eviction proceedings or he's filed a writ, then he agrees not to request a writ and not to move forward or to dismiss any eviction judgment against the tenant at the time. Now, if the tenant does not pay according to this schedule, the landlord can go ahead and file that writ or go ahead and execute that writ, and he's entitled to exercise all remedies under the lease for non-payment. So the tenant's agreeing to pay according to the schedule, and he must do so. Now, on the commercial side, do I have to pay rent? Yes, there's no laws that have been passed that will forgive rent payments. And what if I can't pay the rent? Again, tell your tenant to have a conversation with the landlord. It's extremely important that they communicate with each other during this time. But if they agree to some kind of forbearance, then they would use the form TXR 2126, and they would specify what that forbearance period is, and then fill in the percentage of the rent that they will pay from line A of the commercial lease, and the additional rent they will pay, the percentage of that, from line B, 4B on the commercial lease. And we'll go to that form in just a moment. There's 2 other questions that we've been asked. Can I lock a tenant out for non-payment? And the answer is yes. The Texas Supreme Court suspended evictions, but only residential evictions. They didn't suspend commercial evictions. And can I terminate based on COVID-19? No, there are no current laws that will allow an early termination. So here is the commercial lease rent forbearance agreement. And where I was talking about is in paragraph A, where it says that we must specify a time period, which will become known as the forbearance period. And then during that period, the tenant will pay at least what percentage of the base monthly rent from paragraph 4A of the lease, and what percentage of the additional rent from paragraph 4B of the lease. And then after the forbearance period, in paragraph B, the tenant agrees to pay all amounts due, all the amounts due, however much he didn't pay, in how many equal monthly installments. That could be 1, that could be 2, it could be 10, it can be whatever the landlord and the tenant work out here. In addition to the payments under paragraph B, the tenant will timely pay all other amounts under the lease and comply with all other provisions of the lease. If the tenant strictly complies with this agreement and the lease, he can continue to occupy this premises, and the landlord will not pursue any remedies for failure to timely pay rent under the lease. But if he fails to follow this agreement, then the landlord's not required to give him any notices. He can lock him out. He can exercise all remedies under the lease. Time is of the essence as far as making these payments under this agreement. Now, there are also forms for our contracts, and let's talk about the residential one. It can be used with our 1 to 4, the new home, both the incomplete and completed, the residential condominium contract for resale, the unimproved property contract, the new residential condominium, both complete and incomplete. So what it does is it provides for an extension of the closing for 30 days if the closing cannot occur due to voluntary or mandatory quarantines or closures. And if it still can't close after that 30 days, either party, the buyer or the seller, can terminate the contract and the earnest money is returned to the buyer. It also provides the parties, either party can terminate if the buyer is unable to fund the loan past the third-party financing date due to a loss of income from the COVID-19 related issue. The buyer again receives that earnest money. So this is what the addendum for the residential does. It extends the closing for 30 days, and it allows either party to terminate if it doesn't close in that 30 days or if it gets past the third-party financing and they've lost their income due to COVID-19. What it doesn't do, and when it's not appropriate, is if you just want to close on a different date, you want to change the closing date to a certain date, you would use the amendment, of course, the TXR 1903, and you would fill in paragraph 3. If the parties want to extend the third-party financing approval date, then they would also use an amendment, and they would fill in the date on paragraph 7. If the parties wanted to terminate the contract, you would use the termination form, which is the TXR 1902 for the buyer and 1950 for the seller, and the release of earnest money, which is the TXR 1904. These are our standard forms that we use to amend contracts and to terminate contracts. So if you have a certain date, like we just want to move it 1 week, we would use an amendment. We just want to extend the third-party financing for a week, we would use the amendment, not the COVID-19 form. And this is the actual COVID-19 form, and it says that this is an automatic delay, and it says that if after that delay of 30 days you still can't close, then the earnest money will be returned to the buyer. Either party can terminate. It says that they agree in paragraph B, that if the buyer hasn't removed the financing addendum and he's unable to close because of a loss of income due to a COVID-19 related issue, then either party can terminate, and again, the earnest money is returned to the buyer. Now you will notice down here that it says buyers and sellers are advised to consult an attorney before signing. And they mean a real estate attorney. Give them 3 real estate attorneys if they have any questions about this form, and have them consult with a real estate attorney. Also, note on this particular form that it says the addendum changes the obligations of the buyers and the sellers as follows. A possible extension of the closing date in paragraph 9 of the contract, and a possible termination of the contract beyond terms provided in paragraph 2 of the third-party financing addendum. Okay? So let's talk about its commercial COVID-19 addendum. It's used with either the commercial contract, improved or unimproved, and it would be used for the same reasons as the residential form. It would also not be appropriate for the same reasons as the residential form. If you just want to amend the contract on the commercial side, you would use the TXR 1932. If you just wanted to change the feasibility period on the commercial side, you would use the TXR 1932. And to terminate, you would use the form TXR 1904. This is the form, and it's exactly the same, except that paragraph saying what it changes is removed on the commercial form. But this is exactly the same as our residential form. And again, this one tells us that we'd want to consult an attorney if we have any questions at all. So these are the forms that our TXR has provided us in order to handle the COVID-19 issues that we're seeing. If you have any questions, please feel free to email me at lbenink@kw.com. That's LBENNINK@kw.com. Y'all have a great day.